All right, so this is part two in a series on Florida trust administration. I'm trying to answer the most searched questions in Google and AI and provide you the basics that you need to know about trusts in the state of Florida, whether you are the trustee who's charged with administering this thing, or importantly, if you are a beneficiary, someone that's entitled to trust administration. So I started the series talking about this example of this guy that called in. Dad was a multimillionaire in over years or decades, in fact. He had not gotten the accounting that he was entitled to under Florida law. And I called up this big shot attorney and I asked for the accounting, and the guy said, "I'm not giving you any accounting. This guy's entitled to the accounting." I went, whoa, that opened my eyes. The out-of-state trustee was in hot water because he was not complying with Florida law. And what this big shot, tall building, Ivy League lawyer didn't understand was that he had very much violated Florida law by administering this trust for people that lived in Florida with a guy that lived here in Florida and was completely ignoring the Florida law. And as that case developed over a series of months and then years, and we finally started to get the accountings, we saw that, whoa, major problems in what was happening. Why? Because the big shot Ivy League guy up here at the top of the pyramid was in fact helping himself to a lot more of that trust than he was entitled to, making a lot of decisions under that trust that were absolutely not in the best interest of the beneficiaries of the trust or of the guy that left the trust. So what does Florida law say about trust? Super simple. Number one, Florida statute provides a very crisp, very clear set of absolute requirements, and we go through this checklist. And the first most important one is you got to identify who are the qualified beneficiaries. If you are someone that's entitled to take under a trust, you are what's called a qualified beneficiary. That comes from Florida law. And what does qualified beneficiary mean? It means you have standing. That means you have a seat at the table. That means you are the one entitled to all of the protections, all of the information that is provided under Florida statute. And as you think about qualified beneficiary and you think about this concept in Florida law about what you're entitled to, it's really helpful that the trustee really understand in a specific way what qualified beneficiary means. Qualified beneficiary means, my friend, Mr. Trustee, you work for that qualified beneficiary. And you had better start at the very front end of being a trustee. I don't care if you're a big shot Ivy League tall building lawyer or the uneducated uncle of the guy that died or brother of the guy that died. The bottom line is this. When you are a trustee, you work for the qualified beneficiary, and you got a duty, you got an absolute obligation to comply with Florida statute. And that's embodied in an entire section called 736, and that's the whole section that deals with trust accounting. Now, for you probate practitioners out there, you lawyers that, client comes in and they got a simple will and then they got this trust, you had better provide very specific instructions to your client, the trustee, so that your client, the trustee, does not get in the kind of hot water that I see trustees get into over and over again. And a huge part of that is alerting them, educating them about what the rules for trust administration are. And if you're a trustee, I want you to think about this. You go into an attorney's office and you get an estimate or a bill for what this is going to cost, and it kind of shocks you. Oh my God, 10 grand, 20 grand, whatever that number is, it's a big number. And you got to understand why that comes from. And that's because doing it wrong, administering the trust wrong, as an attorney not advising your client properly what their duties and obligations are, can subject you as the attorney to a whole lot of liability. So that's why it's expensive. You do not have to accept the job of trustee. If your brother has made you the trustee and you're looking at this thing and maybe you don't got a great relationship with the nieces, the nephews, whatever, and you're starting to get the spidey sense that this is going to be a problem, you may just decide that I don't want this. I'm going to decline to serve as trustee, and that's perfectly acceptable. Frankly, in a lot of cases, that may be the best option. I'll completely digress here, but let's talk about where that could come into play. I've seen this happen over and over again. So brother establishes a trust decades ago when maybe brother, wasn't totally successful. Maybe he didn't have a ton of money or whatever, but he establishes a simple trust. Seems like it's simple enough, and I got just a couple of kids over here, and that could be an easy situation that his brother might wants to be the trustee. But what happens if brother over here becomes wildly successful and starts making lots of money and is investing over here in this real estate, investing over here in this business, and along comes a new girlfriend that becomes a wife, and then all of a sudden you got not just one kid but multiple kids, and now you got different factions. You got maybe the kids of the trustee or the grantor, and then you got the step monster wife, and then you got her kids, and now all of a sudden your damn brother that made you the trustee of his trust has thrown you smack dab in the middle of a nightmare that you don't want any part of. You don't got to be part of it. Decline, walk away from that thing. But in my mind, one of the most important things is the trust accounting. And 736-08135 dives down to very clear detail in what is required in here. Number one, we got to capture all this information about what's in the trust at the beginning. And I've seen this original sin where things get really wrong at the front end. Dead guy has his assets all over the place. Doesn't even have all the accounts titled in the name of the trust. He's got a Schwab account that's in dead guy's name. He's got a Vanguard account that's in the trust name. He's got a T. Rowe Price account that's in some other trust name. So again, dead guy over here completely screwed up in getting this trust set up at the beginning. Putting that accounting together is going to be a nightmare. I will tell you that very rarely do I get involved in actually doing the accounting in here. I have the philosophy that as an attorney, my job is to go to court, prepare the pleadings, and do those documents. I almost always hire a separate independent accountant because, in particular in these big situations, I don't want to be responsible for the numbers. I want a certified public accountant, licensed, responsible, and that accountant grabs all those documents from all over the place, all those accounts all together from one place, puts them together in a report that we can rely upon and that can educate my trustee about what's going on with this money that's flying all over the place. Another part about that is I don't want my trustee, particularly when they're a civilian or someone that have a lot of experience in accounting, I don't want them in the deposition being asked questions about what all this stuff is. I want my trustee looking at the licensed professional and relying upon the information that licensed professional provides as the fact witness, as the one that's going to answer the questions to all the beneficiaries, as the one that's going to testify in court about what happened here in this whole trust. And that's even in a properly administered trust. Again, another diving deep into this thing. If we do this from the front end and specifically, gather all this financial stuff together, get it in the hands of a CPA, get it organized properly, get it in a fiduciary accounting standpoint basis, it removes a lot of the potential for liability of the trustee and gets the discipline started at the front end. But from the front end, trustees got to understand what the responsibilities are, what's money that's proper to be spent, what's money that's not proper to be spent. If there's ever any question, we go to court, we get the judge to sign off on what was spent. We always get all the beneficiaries to sign off on it. That's the gold standard in proper trust administration. Trust administration and that accounting has to be provided right at the front end, and then at least once a year is absolutely the gold standard and absolutely should be. We had better be communicating to the beneficiaries at every step in the way. Here's what's in the trust. Here's what we're spending on. Let's talk about what happens when that doesn't, and this is what the call that frequently comes into my office. We file immediately. You don't wait around on these things. By the time it's come to my office, this thing's bubbled up to a problem. We get in front of the court. We're able to identify what the problems are. We bring all those documents in. We bring all the accounting. Oftentimes, we hire forensic CPA to come in and explain to the judge, look, here's where the trustee's wrong, and here's what the problem with this is. So that's the answers to those questions about what is this trust accounting, the single most important piece of information. If you're a beneficiary, you're not getting that accounting, you need to know that. If you're a trustee and you're not doing it, you especially need to know that. I'm going to do another post here about other trust responsibilities, and if you have additional questions, leave or comment in